वेलकम टू रोहिला स्टेनो क्लासेस। आपका डिक्टेशन शुरू होगा 3 सेकंड बाद। स्टार्ट। द स्टेट इन इट्स अपील कंटेंट्स that whether the track was muddy or slippery as to permit a competitive run for the purpose of recruitment at all was disputed. Stop. It was pointed out that none of the writ petitioners had completed the mandatory run of 13 rounds. Stop. The state argues that out of 309 candidates, 159 candidates in fact participated in the PET, of which 82 qualified. Stop. In support of this argument, the state relies upon the additional affidavit filed in a companion case within bracket Suresh Vishnoi versus State of Rajasthan and others, DB Civil Special Appeal within bracket W number 228 oblique 2019 bracket close, which was heard but later on withdrawn by the candidate. Stop. The said affidavit annexes tabular statements that disclose facts and details relating to each stadium and the PET conducted in respect of various commissionerate and battalion, which was resorted to by the state police for recruitment of police constables. Stop para. The state argues that out of the 151 candidates who participated in the PET, no less than 82 within bracket or 54.9% bracket close qualified and were declared successful. Stop. Therefore, the approach and directions of the learned single judge were not justified in ordering a fresh PET. Stop para. Counsel for the writ petitioners urged this court not to upset the orders of the single judge, stating that the conduct of a fresh PET provided a level playing field to the candidates who could not qualify in the previous physical test, especially the 5 kilometer run, because the conditions at the time of the test and the venue were in the most unconducive conditions. Stop. This resulted in arbitrariness. Stop. Counsel emphasized that the mere circumstance that some candidates qualified or that the petitioners participated during the event did not render the recruitment process any less illegal or discriminatory. Stop. Therefore, the directions impugned by the learned single judge were sound and did not call for interference. Stop para. In a recent decision of this court dealing with a similar situation where retest had not been permitted but was granted in some other venue, a learned single judge had held that the refusal to grant a retest was discriminatory. Stop. Setting aside the single judge's order, this court held, after quoting observations in Sarvan Kumar Chaudhary versus the state of Rajasthan and others within bracket DB Special Appeal writ number 154 oblique 2019 decided on 22nd May 2019 bracket close, which had dealt with precisely the same issue concerning a direction to grant retest because stadium conditions were bad. Stop. दोस्तों, यदि डिक्टेशन अच्छा लगा हो तो वीडियो को लाइक करें, शेयर करें और चैनल को सब्सक्राइब करके बेल आइकन अवश्य दबा दें ताकि लेटेस्ट वीडियो का नोटिफिकेशन आप तक तुरंत पहुंच सके।